So do you have land which you own together with your investment club buddies, with a friend of yours, with your spouse, and you all got registered on the title at the same time? Today we are talking about co-ownership of land. We are going to speak quite some English. You'll hear things like joint tenancy, tenancy in common, but it's good for you. It's important that you get to know about this. This is Street Law and my name is Aine. So today we are talking about co-ownership of land. Either you are called joint tenants or tenants in common. I told you we were going to speak some English, but we are going to only measure on joint tenants. Who are joint tenants according to the law? If you bought land together with somebody else and get registered on the title, all of you have 50% ownership in that land, irrespective of the amount that you brought when you were buying the land. So, but for us to establish whether or not you're joint tenants, there are 4 elements that you must fulfill. The first one is you bought the land at the same time and got registered on the title at the same time. When you look at our titles in Uganda that are issued by the Ministry of Lands, you will realize that at the beginning they show you instruments. They put an instrument number, and then they put the date, and then they put the time on which, or the time at which you were registered as the owner of the land. So the title will read something like instrument number this on 22nd July 2023 at 2:30 p.m. Then it will show you Simon Bukenya and Chiza Isaac. Those people got registered at the same time, same instrument number. The second element is when you bought the land, you got the title to the land or the interest to the land together through the same document. For example, you purchased the land, and in the same purchase agreement, you both appear like purchasers. If you acquired the land by inheritance, then you got it through the same will, not the mother's will and then the father's will, but the same will. For example, the father says, I have bequeathed my land to, the land comprised in block this, plot this, to Johnson, Julius, and Joseph. Those 3 acquired their interest in this land in the same document. The third element to joint tenancy is that you take possession at the same time. And on ground, there is no distinctive portions. Each person, all of you own it jointly. There is nothing like I start from here and end here, and then for you start from here and end here. The whole land is utilized by both of you, or the 3 of you, or 4 of you jointly. The very last element is your interest is the same. Interest being the same, I mean, none of you can say that me, I have a chivanja, and for you, you have the title interest. Or me, I have a freehold, and for you, you have the lease of 99 years. All of you must own the freehold or must own the lease, and the same duration applies. So if those 4 elements apply in the transaction that you entered into with your friend, with your spouse, with your investment club friends, that means you are called joint tenants according to the law. So what is the benefit, or what is the legal implication of joint tenancy? The main legal implication is the doctrine of survivorship. What do I mean by that? The survivor takes it all. In case one of those people dies, if there are 2 people on a title and one of them dies, the survivor, the one who remains behind, takes the entire portion to themselves. The family of the person who has died cannot claim anything in this land. This land is not inherited. Tebali sikira. So if I appear on a title with somebody else and they pass on, I will take it all. Their children, their wives or husbands cannot come and claim it. I hope I'm very clear about that. So the survivor takes it all. In fact, all I have to do is to carry my certificate of title to the Ministry of Lands together with the death certificate of this person who has passed on. and they will cross out their name and maintain only my name. This is both an advantage and a disadvantage. In family affairs, where it is husband and wife and they purchase land together, when one of them dies, this land or this doctrine helps in taking out this land out of the land wrangles of the family, because the surviving person is the owner. So I have seen this with especially male clients who are married. They say, I want to put my wife on the title in case I die so that my people don't disturb her. It's an advantage to that extent. But where the people came together to do investment, like say those investment club friends of yours or your casual friend who you invested together with, that's never the intention. So it's a disadvantage that the survivor will take it all. If you are not happy with that survivorship doctrine, if you realize that this is not what you signed up for, then you can do what we call severance. You can end this joint tenancy. There are modes of ending it. Either you sell out or do another documentation on top of what you have to clarify that we are not tenants in common. I own an acre, you own an acre, but the 2 acres are in one title. So it's very, very important. So before you get into land co-ownership with your friends, with your spouse, it is important that you know the legal implication. If this is exactly what you want, that the survivor should take it all, then that's okay. But if it's not exactly what you want, it is important that you go ahead and clarify what your ownership, your land co-ownership entails. Like I told you, you can end it if you're already in it by another document, by what we call severance. If you're comfortable with it, well and good. That is it from Street Law today. I am sure this message, this information was very helpful. It's a lot of English, but I'm sure you understood it. Don't forget to subscribe, hit the notification bell so that you get notified every time I post videos. Until next time, bye-bye.